Yes.
My lord, appeal of 2017. The appellant is a AIDS patient, so he is being released on bail 2-month basis.
Mm-hmm.
He is being released on 2-month basis,
Mm-hmm.
and he has already surrendered. So let it come any day.
It's a division bench matter.
Division bench matter. Your lordship's matter. Above life also.
Mm-hmm.
My lord.
No, but there was a condition that they should be at least in custody for 7 years.
No, he is being released on 2-month basis because he is an AIDS patient. 2 মাস basis রে তাকে দিয়া চালিছে।
ଦେଖିକି ଦେଖିବେ ସେ category ଆସିବ ପଡ଼ିବ। 13 years. Then you give it.
Imprisonment is life, my lord. The principal accused has been released on bail, my lord. And the present appellant, my lord, in the custody, my lord, near about 9 years, my lord.
AC ଚାଲିଛି। Yes.
Weekly list item number 1.
Is that deposition copy came? It has been handed over to you, both of you. Who is that witness that PW1 in this?
Well, so the Damanta Sabur was not rejected.
Just a minute, just a minute. Don't be hurry. This particular statement was given after her statement was recorded in the first time or after that.
Madam.
Just a,
PW1.
what is the date of deposition of
Madam,
PW1?
It was, my lord, 31st July 2017. And this deposition was, my lord, on
14th November.
Madam,
Okay, so after that.
after 3-4 months.
It's all right.
Madam.
Have you gone through that? Are you noticing what is the basic difference between the two?
Totally different. Nowhere
Not
says about it.
totally different, but there are
The
major.
important part, my lord, regarding use of these pesticides, and it is piercing on the body, not there. She was in the meeting, not there. Here she has said that she has been detained. That's why she has not lodged the affair. Madam, see para 7.
That confessional statement by all the accused
Not
persons in that hill area, that is not there.
Not there. She was present there.
And her patients also. The next time he said that that juvenile confessed that.
Who is there? She has said that the other person that returning back the gold chain, that is not there.
Many things have been omitted here.
That's why the court has taken adverse.
PW 5, my lord. PW 4 is the Singh Sabar matter. And I have a glance on para 3 and 4.
Which case?
My lord,
No, we are
go
we
to
are
the
seeing that
Schedule 12
in
that.
view of the provision of additional evidence, which is that this court at this stage, this evidence has come. Now it is up to the learned counsel for the appellants to take resort to any provision or not. That is up to them. But
Right.
as we find, just for a say, in the interest of justice, we called for that.
ସେଇଥିରେ ମାନେ ଏଇ ଡିପୋଜିସନ ରେ
Hmm.
ଦାରା ସିଂ ସବର ଗୋଟେ ଏପିଡବ୍ଲ୍ୟୁ 4 ଅଛି ସେଥିରେ ବି ହୋଷ୍ଟାଇଲ ହେଇଥିଲା he sometimes stated that
PW4.
Myra
Yes.
Parasti and 4 after being hostile and grasped by the prosecution
Conjoint reading of
No, that is not the evidence.
continuation, my lord.
That is not the evidence given. You have to consider that if this evidence comes, this PW12, no?
Again, period 12 again.
Then what would be its evidentiary value? That is to be appreciated. So that's a different matter. But some difference are there in that. But
No, after the evidence was recorded by the JJP, whether any of the witnesses were recalled to
In-
confront the same?
In the particular case, in the my lord, where
In the
you
present
where,
case,
my lord, pardon?
in the present case,
My lord.
whether any of the witnesses were recalled after
No,
such
no.
evidence received by the JJP?
No. So the only alternative available to you is if you think proper. So it is only by way of additional
Okay, sir.
evidence that such a thing has been
Not been
that petition has to file. Then they may be given also
opportunity for
opportunity.
hearing.
Then
Thereafter, my lord, may pass.
thereafter, and
My
if any order is passed, then that is different matter.
lord.
But otherwise, we cannot just take into
No,
account
obviously, my
this.
lord. On our submission, my lord, unless and until the paper will
All
come
right,
and my lord.
we have seen Mr. You can continue, Mr. Continue. So in that case, if your prayer is to recall that particular witness, then obviously that principle which is there is to be followed.
Followed,
That
my lord.
what particular questions you want to put,
My lord.
and if
In questionnaire form, I will
if
put
the
it.
court thinks this court, then it can direct taking of the evidence
For the limited purpose and
it can send to the trial court for that purpose.
It is up to their wisdom.
and my lord has also
And if so
yesterday
advised.
directed me to search for any judgment of the apex court wherein this witchcraft is a property and the my lord, mass killing was there. I have found out, and there it has also been held in 3 judgment that solitary witness will not be sufficient in such a case. I'll post submit also.
So
391.
what it says 391.
Madam.
Please
Madam.
read it out.
What is it? My lord, 391.
Yes.
It starts, my lord. Mhm. 390, 391. Appellate court may take further evidence or direct it to be taken.
Yes.
In dealing with any appeal under the chapter, the appellate court, if it makes, if it thinks additional evidence to be necessary, shall record the reasons and may either take such evidence itself or direct it to be taken by a magistrate, or when the appellate court is high court, by a court of session or a magistrate. Second, when the additional evidence is taken by the court of session or the magistrate, it or he shall certify such evidence to the appellate court, and such court shall thereupon proceed to dispose of the appeal. The accused or his pleader shall have the right to be present when the additional evidence is taken. The taking of evidence under this section shall be subject to the provisions of chapter 23 as it were an inquiry.
Yes.
So, my lord, permits, my lord. Here,
no
the
question of
Honorable Court
permission.
can.
There is a provision. We just go through it.
No,
Is
no,
up to you.
my humble submission, by this provision, it also, my lord, gives a long hand to my lord to pass order, even if the Honorable Court founds that additional evidence is necessary. Even if
No. You are the best person.
no, I
you
will.
say.
My humble
You
submission,
are
my
the
lord,
best person whether that witness is to be recalled, and if so, then what specific questions you want to put because of this evidence. The questionnaire should be there, and opposite party is to be given an opportunity. That petition is to be considered, and whether it would be allowed or not, that's a different matter. Then we'll decide whether we'll take the evidence ourselves or it is to be sent to the trial court, so that he will, after finishing it, it will be sent. So
Okay.
that is all the. So
Ma-
yes, Mr. Das, you can proceed. You.
That judgment, my lord, I was given yesterday, my lord. Samusundaram.
Which judgment you want? Somsundaram.
Yeah. Yes,
Which paragraph?
yes, my lord. Paragraph, my lord, 141 stats.
And Mr. Chand and the other council and council is not there.
Just
You must simultaneously file a short written note of submission and citations, if any, you want to rely on which point and which paragraphs are relevant for this. Just don't make it
voluminous.
yes, voluminous. Yes.
141, my lord. I got it, my lord. Para 141. It is clear that the deceased was adopted on 30/12/2001. It is also established that he was confined illegally at the upstairs portion of the factory at Modhipur, owned by Pidul 34. It is clear from the evidence that it was the body of the deceased which was cremated, and fictitious name was used and a certificate issued at instance of Pidul A3, Appendix 3, which circumstance is clinching in establishing the prosecution case. As far as the murder is concerned, there is no direct evidence. There is no direct evidence that deceased is murdered by strangulating him. However, it is equally true that on the basis of recovery made at the instance of A16, a nylon rope and chain was recovered, which undoubtedly strengthened the prosecution case. There cannot be medical evidence relating to the murder in case where the body stood cremated. We have no hesitation in ignoring the evidence relating to recovery of certain parts of the body of the deceased, but it is not sufficient for the accused to persuade us to throw out the prosecution case. A careful thought out criminal plan has led to the cruel snuffing out precious life. The prayers thought it through meticulously by destroying the corpus delicit by cremation. 142. The abduction followed by the murderer in appropriate case can enable a court to presume that the abductor is the murderer. Now, the principle is that after abduction, the abductor would be in a position to explain what happened to the victim, his victim, and if he failed to do so, it is only natural and logical that an irresistible interference may be drawn that he has done away with the hapless victim. Section 106 of the Evidence Act would come to the assistance of the prosecution. In this regard, it is necessary to look at what this court has laid down in State of West Bengal and versus Mir Mohon Omar. And I'm going to the subparagraph 13 matter. Section 364 Indian Penal Code says whoever abducts any person in order that such person may be murdered or may be so disposed of as to be put in danger of being murdered. He commits the offense punishable under the section. So, important task of the prosecution was to demonstrate that abduction of Mahesh was for murdering him. Even if the murder did not take place, the offense would be complete if the abduction was completed with the said objective. Conversely, if there was no such objective when the abduction was perpetrated, but later the abductor murdered the victim, Section 364 Indian Penal Code would not be attracted. Though in such a case, the court may have to consider whether the offense of culpable homicide amounting to or not amounting to murder was committed. In this case, the trial court has convicted the appellants under Section 364 Indian Penal Code, and this is apart from also convicting them either under Section 365 or under Section 365 read with Section 109 as already discussed. This court in latter judgment reported and turned down the request of the appellant to reconsider the ratio laid down in State versus West Bengal versus Mir Mohammed. In the said case, the conviction appears to have been only under Section 302, though read with Section 34 of the Indian Penal Code. It is pertinent to note what this court held, speaking through Justice.
So, Mr. We
Ma'am.
have gone through it. So, what it says that in this case which you just placed,
My lord.
there not only the abduction was there, there was also evidence of illegal confinement. Just second line.
Well.
Third line, that dead body was cremated. That evidence was also there in the name of another person. So all these things were there. In that context, the court said that if somebody abducts and thereafter it was found that that person has been murdered, then the burden shifts under Section 106 of the Evidence Act to the person concerned to explain, because that was within his special knowledge. What happened after abduction? If he has parted with the deceased after abduction, then he has to say, he has to prove it. He has to discharge that burden. If he fails to discharge that burden, so then obviously 106 would be attracted and he would be seen, it would be deemed that after committing the offense of abduction, it is he who has committed the murder. Right? In this case, the only evidence is that the accused persons phase by phase, if the evidence of PW1 is accepted, took the three deceased persons from that cow set, right?
No, I am on the first statement. From there they took away, but I am in the first occasion that when they tied up the deceased persons in the cow set, this is abduction. They took the deceased persons to the cow set. There they tied up. There they assaulted. Then they are shifted to different places. So this abduction is also, my lord, coming under this, my lord. So now,
after, unless you prove
my lord,
that they are also a party or by direct evidence or circumstantial evidence, that what has happened thereafter is also linked to this
my
one.
lord.
So that thing will come only when you prove that the murder has been committed.
My lord, when I, my lord, the murder, because in this case also, present case, my lord, the judgment, my lord, there is no direct evidence regarding the murder, my lord.
No direct evidence, no medical evidence, no circumstantial evidence.
Here, my lord, in this case also, I am placing the case, my lord, where it is about the murder of the that it has stated that there is no direct evidence regarding the murder of the deceased persons. The fake certificate was produced, but that is one evidence. Another, the nylon rope was there.
No, you again read, please read. after abduction, the abduction was made on 30/12/2001.
My lord.
It is also established that they have been confined in the
Confined
upstairs
illegally.
on the so and so.
Here also they have
ତାପରେ ଆଉ ଗୋଟେ evidence ଆସୁଛି body of the deceased which was cremated,
Hmm.
that was also found and it was in a fictitious name.
name.
So all these things were taken into consideration, and in that context, and apart from that, that nylon rope and chain
Yes.
that was also recovered.
And
In this case, except that they were assaulted in that cow shed, of course, what is the nature of injury caused? Nothing is not. One person sustained bleeding injury, others no external injury. Thereafter, what has happened? No direct evidence, no medical evidence that death has taken place, and no circumstantial evidence also that those assays or those those bones were at all human bones or not.
that's
So,
why the corpus delicti is applicable here, my lord.
Hmm.
The corpus delicti
Hmm.
will applicable here because after they took away the deceased person from the eye of the widow one, my lord. What happened thereafter? Nobody knows, my lord. So it is there. They have to stay. Then what is the where they went, where they go, where is the whether they are alive or not? That is their burden there to prove they what they did with that deceased persons. Because after that, nobody found them. Either they're alive, if their submission is that whether they're alive or not, that is they have to say what they did with the deceased person of the three deceased persons.
So once they took the deceased,
After
deceased,
being brutally assaulted, unconscious state of my unconscious state of the deceased person at the moment they took away the dead the deceased person from the eye of the widow one.
yes,
Thereafter, what they did with that, where they thrown or where they left or where they kept them, what where they went, they vanished thereafter. Nobody has seen them. Now this is the bottom of that. They just tell them how they where they took them and where they thrown or where they put the deceased person anywhere.
So whether according to you,
Hello.
even if the body is not found,
Yes, ma'am.
but when the person was alive, the accused persons took him.
Well.
So thereafter, merely because the person, the abducted, was not found, it is to be presumed that they have been murdered.
They have been murdered. That is their burden.
अरे ଆପଣଙ୍କ
ଆମ case ला they have been murdered.
ଆପଣ କେସଟା
ଆମ case ला they have been murdered by them. As because there is no direct evidence, my lord. I'll come to that at corpus delete, my lord, on different judgment, my lord. Before going to my lord, can I just finish this another three paragraphs?
Since the victims disappeared,
My lord.
so the case of the prosecution is that an inference may be drawn
My lord.
that they have been killed. And with the inference, the defense is to discharge the burden in terms of Section 106 Evidence Act to explain what happened to them.
Exactly.
That's your submission.
Exactly.
You see, in the case of corpus delicti, it is established, it is to be established by the prosecution that murder has been committed. Even if the body is not found, that would not be a ground to disbelieve the prosecution case. Well, acute. This is the basic difference. But unless you prove, suppose somebody has committed the murder and threw the dead body in a stream, so dead body is not found. But the defense cannot raise a contention that merely because that is not found, so no medical evidence there, so therefore it cannot be said that the accused are to be acquitted, because they have otherwise proved that the accused role in the commission of murder.
In some cases, my lord,
Yes.
where the one person is kidnapped by the abductors, my lord.
Once he is kidnapped,
Kidnapped.
yes,
Oh.
then his dead body was not found. No, not established.
Established that.
So, where is the possibility is there or not? Let us say that the accused remains mum. The accused not says anything. Whether the immediately the burden would shift to him and to explain everything, or it would be the court is to jump to the conclusion that thereafter murder has been committed. Let us say
Understood.
after few years he may come up if it is found to be alive. That possibility is there or not?
Yes, ma'am.
So the court cannot, on the basis of surmise supposition, merely because after, let us say, X assaulted B and took him. Thereafter, B's whereabouts is not known. X is not telling anything. So can the court in such a circumstance would jump to the conclusion that merely because he has assaulted, so he must have been, the death must have been taken place. So
Exactly.
murder has been committed. So we'll punish the accused for committing murder to the X. So that is the basic thing.
Because-
Corpus delicti re जोठी आपण केस कन्विक्शन करा जाए सेठी को टाइप रो अन्य एविडेंस थिबा दरकार. That is most important.
I'll place also, madam.
Right.
I have some research.
Ah,
I'll place.
on corpus delicti, if you say that after they were taken away, there is no evidence what happened to them. And let us also accept, or for a sake of argument, that the three deceased persons were thereafter not traced out. And it was also not, the prosecution has failed to establish that murder has been committed. It was also not established that the bone which were recovered by the scientific officer from the cremation ground were at all any human bones or not. That is also not established. Then in such
All
a
these
case,
things will be established. There is no nothing to say that they to shift the burden to the accused person, because it is prosecution has proved all everything. Where it is not proved by prosecution case, there is nothing to prove, like DNA test report and the dead body is not found. All these things and nobody has seen the direct murder of this. In that cases, my lord, the burden should be shifted under section 106 to the appellant person. So what they did with that three persons, where they went.
they failed to discharge.
Exactly.
So can the court jump to the conclusion? We are
My
going
lord,
to the
because-
second part.
again, my lord. So far, in our case, my lord, if you will absolutely accept the testimony of the PW1.
No, we are going on that.
On that-
we
that
are,
way.
let us say, we are accepting
My lord.
that three persons were tied. Let us say, for the sake of argument, three persons were tied in the cow shed. One of them also received bleeding injury. Other two persons received some kind of assault, but no external injury, as your witness says. Then they were taken away one after another.
An unconscious state.
Right. Thereafter, their whereabouts is not known, and you are failing to establish
And-
this part.
Exactly, my lord. Then
Can the court, on the basis of this evidence, Act 106, would jump to the conclusion that murder has been committed, and the accused persons have committed the murder, and they have done this after they cremated, they again brought it out, then they exhumed the dead bodies, and so that is the thing.
If-
Everything thereafter, you want us without any evidence, we are to accept the everything on surmise, because what the information was received to PW1, that is a hearsay evidence. From which source he got the
no source.
information?
Exactly.
Who has given that information? How he knew? The person who has intimated to PW1 that the dead body was brought out, and then the dead body exhumed, and the dead bodies were burnt. So who is that person? How it came to his knowledge? Whether he has himself seen or anybody has intimated. So these are all. So in absence of that evidence, it becomes a hearsay evidence. ଶୁଣା କଥା ତାକୁ ଏଠୁ କାଢି ଦେଇକି ତାକୁ ମୁଁ ଶୁଣିଲି ଆଉ ତାକୁ ସେଠୁ ପୋତିବା ଜାଗାରୁ କାଢିଦେଲେ ତାପରେ ଇଏ କରେ. Can the court accept such evidence?
When they, my lord, under section 106, when the burden of proof lies on the appellant, my lord, if they fail to explain, then only the court can may presume that nah, this has been happened. Unless they explain, I am not saying that directly without giving a explanation, getting the explanation from the appellant, my lord.
जो केस टा आपण आमे अगेन वी आर सेइंग जो केस रा आपण एग्जांपल देकिन जो साइटेशन टा प्लेस करले सेठी अबडक्शन परे जो एविडेंस थिला ए केस रे लिंक माने मिसिंग करची अबडक्शन परे एविडेंस थिला ताकू नै गोटे जगह रे कन्फाइंड करी रखिले एविडेंस थिला जे ताकू नै किनी गोटे स्मशान रे अन्य लोक ना रे पोडिचंती हला एई सब एविडेंस थिबारु कोर्ट कहिले जेहेतु अक्यूज माने ताकू नेला परे किछि एक्सप्लेन करि पारु नांती तेनु it would be against them, it would be utilized against them under section 106. एठी आमे कहया कथा जे आकू नेला परे आउ किछि फर्दर एविडेंस नाही ना सर्कमस्टेंशियल एविडेंस अछि ना आपणकर मेडिकल एविडेंस अछि साइंटिफिक एविडेंस अछि किछि नाही तेनु एई सर्कमस्टेंस रे can we jump to the conclusion that their murders have been committed and all these things which you say 201 etc that has been proved by the prosecution and in such a case also a death sentence is to be imposed.
So, my lord, here in my lord, the in para 142, the case cited, read in Mir Mohan Omar, my lord. Let me that 19 and 20 21 place me, my lord. Let me guess. We pointed out that section 106 of the Evidence Act is not intended to reveal the
relieve the prosecution.
My lord, relieve the prosecution of its burden to prove the guilt of the accused beyond reasonable doubt. But the section would apply to cases where the prosecution has succeeded in proving facts for which a reasonable inference can be drawn regarding the existence of certain other facts, unless the accused by virtue of special knowledge regarding such facts failed to offer an explanation which might drive the court to draw a different inference.
So just take pause for a moment. What the honorable court says that merely because there is a section like 106 in the Evidence Act, it does not relieve the prosecution to prove its case beyond all reasonable doubt. ଆପଣଙ୍କର ରେସ୍ପନ୍ସିବିଲିଟି ଟି ରହିଛି ଆପଣ ସେତିକି ଆगे ପ୍ରମାଣ କରେଇବେ ତାପରେ ଯଦି ଆକ୍ୟୁଜ୍ଡ ଆଡକୁ ଆଙ୍ଗୁଠି ଗଲା ତାହେଲେ ଆକ୍ୟୁଜ୍ଡ ର ସେଟା ସ୍ପେଶାଲ ନଲେଜ ରେ ଅଛି ବୋଲି ଜଣା ପଡିଲା then he has to explain it and if he does not explain obviously adverse inference ଏଇ ହଉଛି ଏ paragraph ଟା
ସେତିକି ରେ my lord on that point my lord. Now the accused persons, if we are going to the evidence of the Procedural 1 and accepting the first person, suppose partially we are accepting for the argument sake, my lord.
Your submission is that abduction confinement is proved.
So after
Considering the evidence of Procedural 1.
Boy,
So therefore, the defense has the burden to discharge.
Under section 106,
Under section 106, to explain what happened to the victims.
Exactly, my lord.
Yes.
That is the question, my lord. My lord, para 20, my lord.
Para 21 ପଢିଲେ
Again, 20 ପଢୁ. We have seriously bestowed our consideration on the arguments addressed by the learned senior counsel. We only reiterate the legal principle adumbrated in the state versus so and so, that when more persons than one have abducted the victim who is later murdered, it is within the legal provision of the court to justifiably draw a presumption depending on the factual situation that all the abductors are responsible for the murder. Section 34 Indian Penal Code could be invoked for the add to the that end, unless any particular abductor satisfies the court with his explanation as to what else he did with the victim subsequently, that is, whether he left his associates en route, or whether he dissuaded others from doing the extreme act, etc., etc. 21. We are mindful of what is frequently happening during these days. Persons are kidnapped in the sight of others and are forcibly taken out of the sight of all others, and later the kidnapped are killed. If a legal principle is to be laid down that for the murderer of such kidnapped, there should necessarily be independent evidence apart from the circumstances enumerated above, we would be providing a safe jurisprudence for protecting such criminal activities. India cannot now afford to lay down any such legal principle
So what
insulating.
does it mean? What does it mean?
Hello.
It means that somebody has kidnapped and it was found to be murdered. है Then it is not necessary that again the prosecution has to prove everything because the burden shifts on him. ये जो second part टा first part टा प्रमाण कले second part टा भी आपनकर murder ହେଇଛି ବୋଲି ହେଲା ताले आपनको explain करिया को पड़िबो जे आपनको जदी ताकू से accused जदी ताकू abduction करिछि एवं तार murder ହେଲା ବୋଲି प्रमाण मिलिला ताहले burden shift ହେଇगला 106 रे ता उपर किंतु आपनकर एठी जो जदी second part टा ही नाही ताले accused to केमती responsible shift हो we are on that we are giving another example to you somebody suppose say husband and wife they were found in a particular house in their house in the bedroom and on the next day it was found that the wife's dead body is lying there and with bleeding injury husband is not available he has absconded right so when they were there in the last night and the on the next morning the dead body was found then it must be within the special knowledge of the husband he has to say that if he has not committed the murder it's a homicidal death is proved then who else so burden shifts on him but suppose in this case you are not proving the second one you are just proving that first one that abduction you are proving if that second part is not proved that any murder has been committed whether in such a case it also requires for them
Our case is that murder has been committed
no,
because
on what basis
Well,
you cannot say that
well,
you must by way of prosecution cannot just say to
Well,
the court that you accept that their murder is
because
committed
as per that, if you accept the totality of the evidence of the PW1,
ନାଇଁ ସେ ସେ
the,
ଯୋଉ
I will go
murder
that
totality ଟା ଆପଣ କଣ
extrajudicial
କହୁଛନ୍ତି
confession
ଆପଣ
before the
totality ଟା
villagers, my lord.
totality ଟା ଯୋଉ କହୁଛନ୍ତି
Yes.
circumstantial evidence ର totality ସେଟା କଣ ଆମେ
Ma-
ଯୋଉଥିରେ
ସେଟା-
କି ଆମେ arrive କରିବୁ
ଆଜ୍ଞା।
ଯେ ସେମାନଙ୍କର
ଯଦି-
murder ହେଇଛି
my lord, if my lord is correct, my lord, but in this case, in our case, my lord, if totality means I am telling about the 164 statement, what we have stated, and it is corroborated to the deposition before the court, my lord, regarding the last scene and regarding the confession of the accused person before the meeting, in the meeting, my lord. That
you have seen just the evidence of
yes, my lord.
PW meeting ଯୋଉ କହୁଥିଲେ ନା ଆପଣ ଦେଖିଲେ ତ ବର୍ତ୍ତମାନ meeting ର evidence we cannot shut our eyes meeting which is not there in the FIR which is not there in the 161 which is not there in one of the evidence of PW1 given in the case of juvenile
Well,
that hilltop ରେ କୌଣସି meeting ହେଇଥିଲା ଯୋଉଠି accused ମାନେ
meeting,
confession ହେଇଥିଲେ only that statement is there in that 164 statement
my lord, para 7. The next day village meeting was convened.
କାହା evidence
ସେଇଟା ଯୋଉଟା ଏବେ the PW12, my lord.
ହଁ PW2 ରେ ପଢନ୍ତୁ କୋଉଠି accused ମାନେ ସମସ୍ତେ ଥିଲେ
ସମସ୍ତେ କହିନାହାନ୍ତି, but
ଆଉ
one of the accused, my lord, the means that is a
meeting ରେ
meeting held, my lord.
ଆପଣଙ୍କର ଏଠି evidence କଣ
My
ଆସିଲା
lord. All the accused persons.
all the accused persons present all of them made extrajudicial confession that we have killed it that is your evidence now read this evidence
The next day a village meeting was convened at the instance of the ward member and the committee sabya. The juvenile confessed killing my parents and sister blaming my mother for the death of his mother resulting from the witchcraft. They confined me to prevent me from
they
approach.
confined me ଛାଡି ଦିଅନ୍ତୁ ସେଠୁ ଛାଡି ଦିଅନ୍ତୁ ମିଟିଂ ରେ କଣ ହେଲା
ଆଜ୍ଞା,
ଏଇ ଲାଇନ ଟା ସେତିକି କହିଛି
ଆଜ୍ଞା,
ଯେ ଏଇ ୱାର୍ଡ ମେମ୍ବର ଥିଲା ସମିତି
ଆଜ୍ଞା,
ସଭ୍ୟ ଥିଲା ଏବଂ ସେଇ ଯୋଉ ମିଟିଂ ଟି ହେଲା ସେଠି ସେ ଜୁବେନାଇଲ ଟା କନଫେସ କଲା
ଆଜ୍ଞା,
he has not stated even the presence of other accused persons
Well.
ହେଲା FIR ରେ ନାହିଁ 161 ରେ ନାହିଁ in court in the trial of the juvenile that is not there
Well.
so how such a statement suppose tomorrow they file a petition to recall and to confront this portion right and it is let us say it is allowed that the question will be put like in that ଆପଣ ଏଇ କେସ୍ ରେ ସେ ଜୁବେନାଇଲ ର ଯେତେବେଳେ ଆପଣ 12 ନମ୍ବର ସାକ୍ଷୀ ହିସାବରେ ଦେଇଥିଲେ ଏବଂ 12 ନମ୍ବର ସାକ୍ଷୀ ହିସାବରେ ଯେତେବେଳେ ଜମାନବନ୍ଦୀ ଦେଇଥିଲେ ସେତେବେଳେ କହିଥିଲେ ଯୋଉ ମିଟିଂ ହେଲା ସେଠି କେବଳ ସେ ଅମକ ଲୋକ ବା ସେ ଜୁବେନାଇଲ ହିଁ କନଫେସନ କରିଥିଲା ଏମାନେ କନଫେସନ କରିଥିଲେ ବୋଲି କହିନାହାନ୍ତି so this question is
There are two parts. If they
so
raise
now
the
this evidence also comes to the court
Well.
now ଆପଣ you are heavily relying on that extrajudicial confession
Well.
এই ଯୋଉ proof କରିବା ପାଇଁ এই ଯୋଉ murder part ଟା
ଆଜ୍ଞା,
right
Well.
so in that case what would happen
Well.
we have to see everything not that
let me
ତେଣୁ
bring this, my lord.
ହଁ,
My lord will take
yes
it.
no now he just placed it he placed it that's
We
what
cannot refer to this evidence
unless it is brought in a
The form.
in the form
That is there, whether they
and we
do or
cannot
not.
also reach at any conclusion
No,
unless
no, no,
until this evidence
right,
is
right.
confronted to PW.
Right.
Exactly.
He may
That is
explain
not
also, he may explain that what has happened or so that is the purpose. Yes.
My lord, here, my lord, I want to place regarding the 164 statement recorded and the
Hmm.
principle of that. And why I'm placing, my lord, will go if I'll place the statement, my lord, para 26, my lord. 26, my lord. May I place, my lord?
Yes, of course.
Evidence given a court under oath has great sanctity, which is why the same is called substantive evidence. Statements under section 161 CRPC can be used only for the purpose of contradiction, and statement under section 164 CRPC can be used for both corroboration and contradiction. In a case where the magistrate has to perform, but this is the most important matter. In case where the magistrate has to perform the duty of recording a statement under section 164 CRPC, he is under an obligation to elicit all information which the witness wishes to disclose. As a witness who may be an illiterate, rustic villager may not be aware of the purpose for which he has been brought and what he must disclose in his statements under section 164 CRPC. Hence, the magistrate should ask the witness explanatory questions and obtain all possible information in relation to the said case, my lord. Here, what happened in our case, my lord, the 164 statement is more corroborated, more elaborated, and more details about the crimes, my lord.
Yes.
It is because only if the magistrate, recording the statement, has done these things, my lord, as the witnesses.
What is your submission?
My lord.
Even somebody has not stated anything in court and magistrate
No,
has
not stated. The
The
questions, what happened in the occurrence, my lord. Here, my lord, the
ଆମେ ସେଇ ଆଡକୁ ଯାଉଛୁ
ଯେ ଯଦି
ଗୋଟେ ୱିଟନେସ୍ ଇଲାବୋରେଟଲି ତାକୁ ଏଇ ପ୍ରିନ୍ସିପଲ
କହିଛି
ଅନୁଯାୟୀ
କି
ହଁ କହିଛି
ହଁ
Court re ନ କହିଲେ ମଧ୍ୟ ସେ 164
No,
କୁ accept
Chetan,
କରାଯିବ। ଆଉ
not my submission, not that matter. Here, I am again reading it, then I will explain matter.
yes,
The magistrate has to perform the duty of recording a statement under section 162 of CRPC. He is under an obligation to elicit all information which the witness wishes to disclose, my lord. As a witness who may be an illiterate, rustic villager, may not be aware of the purpose of for which she has been brought. Means here, my lord, the Pedal 1 is illiterate person, my lord. A tribal girl.
please have patience.
Yes, my lord.
You will be given opportunity.
And has come to depose the evidence before the magistrate, my lord. Here, my lord, matter are the purpose for which he has been brought. Suppose somebody is, my lord, they are answering they are questioning that he is literate. Suppose he is studying in the some classes he has gone. That does not he know about the law? Why he was the 162 statement is recorded? Why he has gone to what to say in the 162 statement? All these things he is not aware. In that respect, he is illiterate regarding the law is concerned, my lord. Now, hence the magistrate should ask. This is the question. Magistrate should ask the witness explanatory questions and often all possible information in relation to the said case, my lord.
It has been done in this case. Yes.
Exactly, my lord.
So-
That's why that is the details of the crime he has disclosed before the magistrate in 164, which has
So
not
your
been
submission
disclosed.
is that each and every incident has not been described in the FIR.
Exactly.
So also in our statement section 161, but it has been elaborated
In the 164.
statement
So
section
that
164,
the truthfulness of the case cannot be not be
which
discarded.
stands corroborated before the court.
Court, my lord.
So,
And that is also in the deposition at the time of deposition, what he has stated, that is to the corroborate to the statement recorded on 164, my lord. My submission is that, my lord.
And when suppose this evidence also comes, keep in mind,
My lord.
that suppose this evidence comes after the re-examination of
That is,
the,
my lord.
then
that basis
you
we'll-
are to
my lord,
again keep in
at
mind,
that time, my lord,
because
my
the
lord,
164 and then he deposed in court on
my lord,
oath.
we'll
that.
discuss in that, my lord,
Yes.
stage, my lord. My lord, para 27.
Yes.
So far as the statement of the witness recorded under section 164 is concerned, the object is twofold. In the first place, to deter the witness from changing his stand by denying the contents of his previous record statement, and secondly, to tide over immunity from prosecution by the witnesses under section. That's now the 157 regarding corroboration, that is there, my lord. Not required to again go for that. This is, my lord, judgment regarding testimony of a single witness and relative relation and interested witness, sole testimony of the witness. My lord, paragraph 20, my lord.
No, para 20, it is from decision of another. What is the observation one? You come to paragraph 38 actually. 38 is relevant.
38, 11, before that, some, my lord, 29, and I will just, my lord, emphasis on something. Let me clear 38, my lord.
Hmm.
From the above case law, it is clear that a close relative cannot be characterized as an interested witness. He is a natural witness. His evidence, however, must be scrutinized carefully. If no such scrutiny, his evidence is found to be uh, intrinsically reliable, inherently, probably, and wholly truthworthy. Conviction can be based on the sole testimony of the such witness. Close relationship of witness with the deceased or the victim is no ground to reject his evidence. On contrary, close relative of the deceased would normally be most reluctant to spare the real culprit and falsely implicate an innocent one.
There is no dispute over
Well,
that principle. It's a well settled law now.
my lord, para 26, my lord. May I place para 26,
20?
my lord.
Hmm.
In Chitralal versus state of Rajasthan,
Hmm.
an occasion to consider a similar question. In that case, the sole testimony of a young boy of 15 years who relied upon for recording an order of conviction. Following and reiterating the law laid down therein, this court stated the legislative recognition of the fact that no particular number of witnesses can be insisted upon is amply reflected in section 134 of the Evidence Act. So and so, administration of justice can be affected and hampered if number of witnesses were to be insisted upon. It is not seldom that a crime has been committed in the presence of one witness, leaving aside those cases which are not of unknown occurrence, where determination of guilt depends entirely on circumstantial basis. If plurality of witnesses would have been the legislative intent, case where the testimony of single witness only could be available in number of crimes of the offender would have gone unpunished. It is the quality of the evidence of the single witness whose testimony has to be tested, and the that particularly that line, my lord, I wanted to place the availability of only one single witness regarding the spot. That is my lord, only my. And others, my lord, I will place regarding the death sentence and other.
Yeah,
How I will place or anything
No,
they
no, we
want
have
to.
finished.
No, they wanted or January wanted to say something different before the death sentence. Otherwise, I will.
Who? Mr.
Mr.
Chan?
Haan.
Pariji,
Then otherwise I'll continue.
no, whether Mr. Chand wants to place some decisions or he will continue and finish, and then you will
There's some more decisions. Let him complete and
You can complete, sir. You can
complete, you
and
complete.
you will respond thereafter.
Might be held up in some other court. Continue. What decisions Mr. Chand and he placed? Two important things is that so far as the murder is concerned, uh, if that what is based on circumstantial evidence or it is based on the testimony of a solitary witness, whether in such case death sentence is to be imposed or it is to be a life imprisonment. In that light, they placed some decisions, two or three decisions they placed. Yes.
Well, para 31.
Where?
31. 3-1.
Huh.
Para. Death sentence, my lord.
Yeah.
Having dealt with the appeals on merits from the standpoint of proof of guilt and validity of other or otherwise of the order of conviction, we now come face to face with the problems indicated when the certain was lifted, namely the application of the rarest of rare cases, rule of the facts of individual cases in context of relevant guidelines. Some reflections on the question of death penalty may appropriately be made before we tackle the said questions in the perspective of the present group of appeals. 32. The reasons why the community as a whole does not endorse the humanitarian approach reflected in death sentence in no case. Doctrine are not for to seek. In the first place, the very humanitarian edifice is constructed on the foundation of a uh, reverence for life principle. When a member of the community violates this very principle by killing another member, the society may not feel itself bound by the sections of this doctrine. Secondly, it has to be realized that every member every member of the community is able to live with safety without his or her own life being endangered, endangered because of the protective arm of the community and on account of the rule of law enforced by it. The very existence of rule of law and the fear of being brought to book operates as a deterrent of those who have no scruples in killing others if it suits their ends. Every member of the community owes a debt to the community for this protection. When ingratitude is shown instead of gratitude by killing a member of the community, which protects the murderer himself from being killed, or when the community feels that for the sake of self preservation, the killer has to kill, the community may well withdraw the protection by sanctioning the death penalty. But the community will not do so in every case. It may do so in rarest of the rare cases when its collective consciousness is so sucked that it will expect the holders of the judicial power center to inflict death penalty irrespective of their personal opinion as regard disability, or otherwise returning death penalty. The community may entertain such a sentiment when the crime is viewed from the platform of the motive for or the manner commission of crime or the antisocial or aberrant nature of the crime, such as for instance 33 manner. When the
this
murder is committed in
this
an extremely
Machishing case,
manner.
it is placed number of time. Which particular because they also place this decision which have been
Manner.
quoted. So it is not necessary to place the entire thing once again.
Manner.
So which are the relevant thing you say? Because otherwise we have gone through this decision on a number of times. Because the principle that has been
Manner.
laid down here, the Bachan Singh has also been followed.
Followed manner.
And
Bachchan Singh is also followed
they have added something
Yes, madam.
to that guideline. So um,
And here the motive part is better regarding the witchcraft is the for which they
yes,
matter.
so just place the relevant
Madam.
paragraph, not the entire thing. Where is that?
Bachchan Singh is there in 38 madam.
Witchcraft what it is dealt in that Machi Singh case.
No, Bachchan Singh now. Madam, para 37 my lord.
Yeah.
But 36 and 37 the multiple murder.
Hmm.
When the crime is erroneous in proportion, for instance, when multiple murders, say, of all or almost all members of a family or a large number of persons of a particular caste, community, or locality are committed. Here, matter the 3 persons from the family has been.
Hmm.
Now, personality of the victim of murder.
No, in the said case, it was a killing spree.
Hmm.
17 persons died, and the Supreme Court held that it shocked the conscience of the collective conscience of the society. Hence, it's a case of rarest of the rare. So that is the principle which has
Yes,
been outlined by the Supreme Court in Machisi. So, what's your response? Does it fit to the present case? Even though there are multiple murders, 3 persons have died.
madam.
Is it a case which shocks the conscience of the
Because
society
in the case, my lord, in
and hence falls within the purview of the rarest of the rare?
madam, because in a small village, my lord, one of the family from the family, my lord, there are 3 persons brutally assaulted in front of the eye of the one member of the family, that is a girl, my lord, was present at the time, and the way they assaulted in that before the eye has till the consciousness and the injection or injected, whatever the allegations are there, my lord, and thereafter they took the dead bodies and they as allegation that they burned buried and that burned. So this type of cases when happen in the society at large, my lord, this is a threat to the that particular community. That if anybody will do such type of things, will do such type of things, my lord. So all these things are to keep in mind, my lord, regarding the
Machi Singh case which you are placing is a case of direct evidence. Apart from that, there was also dying declaration for the.
no, that is, my lord.
Any decision where under the certain circumstances, even if the case is based on circumstantial evidence, there can be death sentence imposed.
Circumstance,
And-
single witness, and this type of maybe that
Madam.
Purpose delicti.
Because this is a case which is based on direct evidence.
Yes, madam.
Your case
Then
is
I am
based on
going to my lord,
circumstantial.
other, my lord. This is my lord. Sebak. Sebak. Perumal God. The state of Tamil Nadu. Para 9, my lord.
Paragraph ଯୋଉ decision ଟା ଇଏ କରୁଛନ୍ତି just paragraph 5 କୁ ପଳେଇ ଆସନ୍ତୁ।
Five.
ର ଯୋଉ 5 lines from the bottom.
Well, we find no force.
No, ସେଇ ତାରି ପର ଯୋଉ line ଟା।
Again.
Paragraph 5,
The
page 476,
my lord.
5 lines from the bottom of that paragraph.
My lord. Juta armoji in a trial.
In a trial.
In a trial for murder, it is not an absolute necessity or an essential ingredient to establish corpus
delicti.
My lord. Yes, sir. The fact of death of the deceased must be established like any other facts. Corpus delicti in some cases may not be possible to be traced or recovered. Take for instance that a murder was committed and the dead body was thrown into flowing tidal river or stream or burnt out. It is unlikely that the dead body may be recovered. If recovery of the dead body therefore is an absolute necessity to convict an accused, in many cases the accused would manage to see that the dead body is destroyed and would afford a complete immunity to the guilty from being punished and would escape even when the offense of murder is proved. What therefore is required to base a conviction for an offense of murder is that there there should be reliable and acceptable evidence that the offense of murder, like any other factum of death, was committed, and it must be proved by direct or circumstantial evidence, although the dead body may not be traced. In this case, the evidence of Article 7 and established that they have seen the dead body of the deceased so and so in the well and found brought it out, and the photograph was taken at the time of inquest. It was identical. Case
So obviously, that's a different
different.
case.
But this particular these things, my lord, regarding the my lord told
No, that very line,
my lord,
keep in mind that there should be reliable and acceptable evidence that the offense of murder has been committed.
Para 9. Let me
In this particular decision.
yes, ma'am.
Yes.
9 টা মজুর আরম্ভ করছি the fact and given circumstances. The middle of this year last E जोटी अच्छी right side रे E तोड़ घुमेलो side रे E लिखा है जो
Yes, sir, there.
हाँ the facts and given circumstances in each case, the nature of crime, the manner in which it was planned and committed, the motive for commission of the crime, the conduct of the accused, and all other attending circumstances are relevant facts which would enter into the area of consideration. For instance, case a murder committed due to the deep-seated personal rivalry may not call for penalty of death, but an organized crime or mass murder of innocent people would call for imposing of death sentence as deterrence. While refusing to reduce the death sentence observed thus, it will be a mockery of justice to permit the accused to escape the extreme penalty of law when faced with such evidence and such cruel acts. To give the lesser punishment for the accused would be to render the justicing system of the country suspect. The common man will lose faith in court. In such cases, he understands and appreciates the language of deterrence more than the reformative jargon. Therefore, under sympathy to impose inadequate sentence would do more harm to the justice system to undermine the public confidence in the efficacy of law, and society could not long endure under serious threats if the court did not protect the injured, and the injured would then resort to private uh,
Vengeance.
vengeance. It is therefore the duty of every court to award proper sentence having regard to the nature of the offense and the manner in which it was executed or committed. ଖାଲି ଗୋଟେ ଗୋଟେ ପାରା only one para only two my lord which para 34 ଖାଲି para 34 in case of Mahinder Singh. It is well settled law that awarding of life sentence is a rule and death in an exception. The application of the rare case principle is dependent upon and differs from case to case. However, the principle laid down and reiterated in various decisions of this court so that in a deliberately manner plan, here it, I place my lord, the deliberate manner plan executed meticulously in a diabolic manner, exhibiting human conduct in a ghastly manner, touching the conscience of everyone, and thereby disturbing moral favor of the society. My lord, you can hear what happened. It is planning, my lord, meticulously they have done, deliberately plan is made, and they tied up, and then they did what after they out of the eye of the. So that's I only wanted to point out, my lord.
The next line, this is important also, that whether
Madam.
there is a possibility of reformation of a criminal or not, that is also to be taken into account. So one thing, Mr. Let us, we asked you, I think yesterday, that whether there is any evidence or any material about any criminal antecedent.
That is
You
not
said no. Now they are also staying in jail custody for last 6 years, I think, 18 days. So is there anything against
not
them?
also and no idea. So to take instruction on that.
Because the court says that those are can be also taken into account. This, apart from that heinousness of the crime, the other factors that is to be also taken into account, that there is no chance of reformation of the criminal. So he is of such a nature. It's because of the past conduct, or uh, so if that is not there, you are not bringing about the past conduct. Now, for the present one, it is he's in your custody for last 6 years, all the person. So anything adverse against them during this period. These are all relevant, Mister. These are all relevant. According to, he also placed some decision. Those that the chance of reformation, and Mr. Kotki also placed those decisions also on that day. That angle is also to be seen. That there is no chance of apart from that other things. So that cannot be. Uh, so. ଏଇ ପାରାଗ୍ରାଫଟାକୁ ଡେଥ୍ ସେଣ୍ଟେନ୍ସ ପାଇଁ ଏଇ ସଲିଟାରୀ ୱିଟନେସ୍ ର appreciation of evidence ଏଇ
Yeah.
paragraph just type it out and give it during course of the day so that it would be elaborate କିଛି ଦରକାର ନାହିଁ just point wise କୋଉ paragraph ଟା relevant ସେତିକି ଦେଇଦିଅନ୍ତୁ ଆପଣ ଯେମିତି ଦେଇଥିଲେ ସେ ଯୋଉ ଆର ଇଏଟାରେ ଦେଇଦିଅ please hand it over. We have also told him don't give an exhaustive note. It is not necessary. Point wise, just give why the evidence of PW1 is to be accepted and meeting their contentious also. Short note it can be given. But yes, you can proceed.
My lord, without reiterating, my lord, I'll place before lordship only what I have read, my lord, in page 287 as far as the aggravating circumstance and
1
mitigating
minute, sir. 1
circumstance, my
minute.
Sure. Just let it be.
lord. Yes. My lord. Page 287 and 288 as far as aggravating circumstance and mitigating circumstance, my lord. Lordship, we had given emphasis as far as aggravating circumstance, serial number, clause number 3 and 9. 287, my lord.
Yes.
My lord. 3, my lord, I am also reading, my lord. The offense was committed with the intention to create fear psychosis in the public at large and was committed in public place by a weapon or device which clearly could be hazardous to the life of more than one person, my lord. No doubt, more than one person is there, my lord. But it is not a public place.
That
Oh.
Mr. Chand addressed yesterday.
Yes, yes.
Sorry.
So,
Mr. Chand addressed us on this particular
okay,
line
my-
which
my-
are yesterday.
so that may not be applicable for the aggravating circumstance, my lord.
Yes.
Your lordship may kindly come to 9, my lord. When the crime is enormous in proportion, like making an attempt of murder, the entire family,
Yes.
Or members of a
or the
particular
members of
community.
a particular community. But it is to attempt of murder, my lord. Making
No,
an
it's see, entire family has been here.
small, two
What
person.
he contended
Huh.
that even though one of the family member was available, but he was spared.
Spared.
So that is how it will
Huh.
not come within this
No intention
particular.
to commit murder
There
to all
will not
persons,
have
my
been any difficulty for killing PW1,
yes.
right? But so
But
this
they are
category, ଏଇ category को ଆସିବାକୁ ହେଲେ ତାକୁ touch ବି କରୁନାହାନ୍ତି
Touch
ସେ
ବି କରୁନାହାନ୍ତି।
କହୁଛି ହଁ ସେଇ yes.
So what the court has held, my lord, your lordship, considering those mitigating, I'm coming to my lord 288, my lord, mitigating, only 2, 4, 3, 4 points, my lord. 2, that the age of the accused is relevant consideration but not determining factor. And 3, my lord, the chances of the accused of not indulging in commission of crime again and probability of accused being reformed and rehabilitated, my lord. I'll give you emphasis on that, on the decision, my lord, emphasis on that. Just those four points I'm reading, my lord, then I'll go to the judgment, my lord. And what the court has said on the what view, though witchcraft has not been said in the as far as when going to convict sentence, when going to pass sentence, my lord. Witchcraft has not been said, but regarding the death, death with the threat of the PW1, so that it created a psychosis fear to him. On that point, the learned court below has stated so. I'll go through it. Only two lines I'll go. Your lordship, 6, where the court upon a proper appreciation of evidence is of the view that crime was not committed in preordained manner and that the death resulted in a course of commission, my lord. So what I wanted to say, my lord, that as far as the direct evidence is concerned, what they say, they were losing sense and getting, my lord. So what they said that they had not died at the spot. Spot means at the cow shed, but they had taken her. So at best, as far as narrated by the PW1, that act taken part by all the accused persons, my lord, that at best it may be for assault, not for death. They have assaulted or injected or giving the lathi blow, my lord. But there is no purpose there is no intention to murder, my lord. And they have not seen the murder, but by the time they had left them, they were leaving, my lord. So what I submit, that this is in course of commission of the offense of another crime, but with the died, it is proved, my lord, it is they are dead, my lord. Then during commission of the crime, he is dead, my lord. So it will not attract under section 302 under death sentence, my lord. 7th, my lord, that it is absolutely unsafe to rely upon the testimony of the sole eyewitness through the prosecution has brought home the guilt of the accused. Here in this case, only basing on the sole evidence of the PW1. So whether that can be relied, fully relied, that is to be seen. Your Lordship, I am just placing before Lordship some decision, my Lord. So my Lord, second copy is not there. I am placing, my Lord, then I will give the notes, my Lord. In one case, my Lord, Digambar versus State of Maharashtra. That is a live law, my Lord, 2023 live law, Supreme Court, 361. In paragraph 27, my Lord, one decision I cited, my Lord. Recently, this court, just I am reading, my Lord, small portion, my Lord, I am reading, my Lord. Recently, this court, in the case of Sundar alias Sundarajan versus State of Inspector Police, held that a rarest of rare doctrine does not require that in such a case, only death sentence has to be imposed. This court held that while considering as to whether the death sentence is to be inflicted or not, the court will have to consider not only the grave nature of the crime, but also as to whether there is a possibility of reformation of the criminal violence. Maybe rarest of rare case, but does not mean that death sentence will be awarded. When the court sees that there is a chance of reformation. So here in this case, from the entire background of all the accused persons, your Lordship will see, prosecution has not shown as to their involvement in other cases prior to that matter. Not the prosecution has stated about lodging of any case or involvement in any case, any place, my lord, other cases. So that is why you say, since they have also remained in custody for more than 7 years, so sold rehithala, sold rehile 24 helani, 7 ବର୍ଷ ଉପରକୁ ହେଲାଣି. So there is a chance of reformation. If your lordship will also come to point that they have committed the offense, rarest of rare cases, still there is a chance of reformation. So this should not be awarded. Paragraph 27, I will give, my lord, I will give that judgment. Then, my lord, another case, that is Aloknath Datta and others versus State of West Bengal. AR Online 2006, Supreme Court 622. Just a portion I'm reading, my lord. There are some precedents of this court. For example, Sahedo and others, etc. versus State of UP 2004 10 SCC 682, and Sheikh Ishaq and others versus State of Bihar 1995 3 SCC 392, which are authorities for proposition that if the offences is proved by circumstantial evidence, ordinarily death penalty should not be awarded. We think we should follow the said precedents instead, and thus, in place of awarding death penalty, impose the sentence of rigorous imprisonment for life as against Aloknath. Furthermore, we don't find any special reason for awarding death penalty, which is imperative, my lord. As far as circumstantial is concerned, let us accept that circumstantial is proved, though they have not proved, my lord. Accepting for the sake of argument that if it is proved that they have brought it to the cremation ground and done this, my lord, nobody has seen, but on the basis of the circumstances, my lord, then death sentence should not be awarded. At best, it will be life imprisonment.
Yes.
My lord. Yes, well, that is 2023 live law, Supreme Court 2017. That is Sundara alias Sundarajan versus State by Inspector Police. My lord, paragraph 89. Considering the above factors, we are of the view that even though a crime committed by the petitioner is unquestionably grave and unpardonable. It is not appropriate to affirm the death sentence that was awarded to him. As we have discussed, the rarest of rare doctrine requires the death sentence not to be imposed only by taking into account the grave nature of the crime, but only if there is no possibility of reformation in criminal, as far as reformation is concerned. So when the court finds that there is no chance of reformation, then court can impose death sentence. This is paragraph 89. My lord. Another paragraph 79. My lord. No such inquiry has been conducted for enabling consideration of the factors mentioned above in the case of petitioner. Neither the trial court nor the appellate court have looked into any factors to conclusively state that petitioner cannot be reformed or rehabilitated. In the present case, the courts have reiterated the gruesome nature of crime to award the death penalty. In appeal, this court merely noted that counsel for the petitioner could not point towards the mitigating circumstances and upheld the death penalty. The state must equally place all the materials and circumstances on the record bearing on the probability of reform. Many such materials, sir, সেটা ডিসিশন কହୁଛି ସୁନ୍ଦର alias ସୁନ୍ଦରାଜମ versus state by inspector police, এটা 2023 ଲାଇଭ୍ ଲ ସୁପ୍ରିମ କୋର୍ଟ 217 3 ଜଜ୍ ବେଞ୍ଚ ସୁନ୍ଦର alias ସୁନ୍ଦର ରାଜନ versus state by inspector police. sir 2023 ଲାଇଭ୍ ଲ ସୁପ୍ରିମ କୋର୍ଟ SC 217. Why I am reading, my lord, the court held while on sentencing, my lord, hearing on sentence, said the defense has not produced any mitigating, established any mitigating circumstance, my lord. That is why I said the aggravating factor tilts in favor of the prosecution.
No, the case, what that decision says, that let us say that it is a rarest of rare
Rare
case, and the defense has not produced any mitigating circumstances.
Yes.
Still then, the duty lies on the state to show that there is no chance of reformation.
Yes.
In that
Yes,
light,
yes.
that decision.
Yes. Paragraph 79 and 89.
Kindly read the lines once again. sir.
Again, one second, please.
My lord. This is regarding, my lord, read, my lord. This is regarding the death of a 7-year-old child, my lord. That is
The paragraphs are again 177.
70, my lord, 79 and 89. Your lordship, I am reading. And that is regarding the Bachan Singh case, my lord. Bachan Singh, previously Bachan Singh. No such inquiry has been conducted for enabling a consideration of the factors mentioned above in the case of the petitioner. Above means the Bachan Singh case. Neither the trial court nor the appellate courts have looked into any factors to conclusively state that the petitioner cannot be reformed or rehabilitated. In the present case, the courts have reiterated the gruesome nature of crime to award death penalty. In appeal, this court merely noted that the counsel for the petitioner could not point towards some mitigating circumstances and upheld the death penalty. The state must equally place all material and circumstances on the record bearing in the probability of reform. Many such materials and aspects are within the knowledge of the state, which has had custody of the accused both before and after conviction. The process after conviction, moreover, the court cannot be an indifferent bystander in the process. The process and powers of the court may be utilized to ensure that such material is made available to it to form a just sentencing decision bearing on probability of reform.
You have noted down.
As far
For 79
Sir,
and
79, 89, my lord, I'm reading.
79 and 89.
Okay. I'll
Read
give
up.
the copy. I'll give a copy.
Okay.
89, I'm reading, my lord. So, considering the above factors, we are of the view that even though the crime committed by the petitioner is unquestionably grave and unpardonable, it is not appropriate to affirm the death sentence that is awarded to him. As we have discussed, the rarest of the rare doctrine requires that the death sentence not to be imposed only by taking into account the grave nature of the crime, but only if there is no possibility of reformation in criminal.
Okay. That is.
Yes. My lord. Then, my lord. I'm coming to my lord.
The case of rarest of the rare is
Rarest of the rare.
excluded. Is excluded. Altogether.
Excluded. Yes.
And even if the
Even though
crime is it has to
he
be
knows.
one,
Yes.
then also if there is a possibility, probability of reformation, it can be converted to life.
Yes. That is. Sir, page 299, if your lordship will see. Just 298 ଆସୁଛି page 63 paragraph.
Yes.
My lord. My lord, as far as finding of the learned court below, my lord, as far as the sentence, my lord, just a portion I'm reading from the 61. It is found that learned defense counsel is not in a position to point out any mitigating circumstance in the case in hand.
କେବଳ ସେତିକି ଅବଜର୍ଭ କରିଛନ୍ତି
ସେତିକି ଅବଜର୍ଭ କରିଛନ୍ତି ଏବଂ
ରିଫର୍ମେସନ କଥା କିଛି ଡିସ୍କସନ କରିନାହାନ୍ତି
not discussed. ତାପରେ ୟୁ ଲର୍ଡସିପ କାଲି କମ ରିଫର୍ମେସନ କଥାଟା ଆଉ ଗୋଟେ ପାରାଗ୍ରାଫ କରିଛନ୍ତି ୟୁ ଲର୍ଡସିପ. Now coming to consider the possibility of reformation.
ଆମ ଏଇ
Sir,
ଜଜମେଣ୍ଟ
judgment. Paragraph 62, page 296. 296, sir. Para 62 ର just ଉପରୁ କହିଲେ as such striking a balance between aggravating circumstance and mitigating circumstance, this court is of humble view that aggravating circumstance would tilt balance in favor of the capital punishment. In the facts and circumstances, it is felt that there is no alternative punishment is left for the convicts than one which is the death sentence. 62, as far as reformation matter. Now coming to consider the possibility of reformation of the convicts, there appears no material on the record to justify the same. The theory of reformation cannot have a universal acceptance but it depends upon the facts and circumstances of each case. It is found from the testimony of the PW1, testimony of the informant PW1, that she was terrified that at the time she was unable to depose, expressing her feelings by words and tried to express her feelings by action.
factual aspect.
Factual, we will not go to only those person.
So now coming to the just a minute. Now coming to consider the possibility of reformation of the convicts, there appears no material on record to justify this. And rather that these are the materials which shows that there is no chance of reformation. That should have been. There is no material on record to justify. And he has shifted as if the burden the accused persons that they are to.
There has been a lot of discussion on fact.
This is only fact. I'm not going to that.
Which is unnecessary.
Only says matter because of this
reformation re factual ये को ये टाकू अपेक्षा past conduct तापर एगुड़ा करे देखी कि नहीं conclusion आसिया कथा जे एई दृष्टिरू एई एभळ्या accused reformation chance hi nahi.
Ah.
So there is no possibility. Then, but what he has stated, just one line, then the Lenin trial court has discussed again the PW1's evidence.
yes, yes. PWR जो activity जो करछन ताको जो
PW
कार्य करछन that is no छेउडा कहउछन information हबार chance नाही
Huh?
हम 63 पढी फाइल कोड 63 जीबी ता
63 mark.
63 64 को जीबी 63 first line go to that the future conduct of a particular man is assessed from his past and present activities where these convicts have failed to justify the philosophy of the reverence and reformation is that one has prospect his life by serving to the society. In the instant case, no previous good or noble activities of the convicts are forthcoming on record or brought to the notice of this court by the learned defense counsel, which is, my lord, not reasonable, my lord.
Earlier, Mr. In section 53 of the Evidence Act, it was there that in criminal cases, previous good character is relevant.
Yes.
There are some amendment to it and two other subsections like that, 53A and 54. Those were inserted in 2013, 3 to 2013. And 53A indicates that what type of offenses that is not relevant. And so far as 54 is that in criminal proceeding, the fact that the accused had a bad character is irrelevant unless the evidence has been given that he has a good character in which it becomes relevant. This section does not apply to cases in which bad character of any person is itself a fact in issue. That is one thing. A previous conviction is relevant as the evidence of bad character. So what the Lenin trial court has stated that since no material is forthcoming that they have done any previous good or noble activities, and the future conduct of a particular man is assessed from the past and present activities. So past activities, you are not saying anything. Present activities is only that occurrence part. Thereafter, what has happened after?
Future activities he has taken regarding the threaten to the
No, that is the course of that same transaction.
same
It is
transaction.
not a. It is not. But again, that very principle, it is said that every saint had a past and every sinner has a future. In while discussing death sentence, this proposition is also taken into account in many cases, that every saint had a past and every sinner is a future, has a future. So, what is your submission now?
And submission
When you
is,
are addressing on death sentence.
my lord, what the court has said, my lord.
No, it is we accept what you say,
Yes,
that
my
there is nothing, or the state has not brought out any material
material.
that there is any kind of criminal antecedent, any criminal antecedent against any of the accused,
Well.
right?
Hmm.
And also they have not brought on record that after they are detained in jail, there is anything adverse against reported against them. They have not brought law. So the only thing is that what has been observed by the London trial court is one is the coming to that rarest of rare case, one thing,
Yes.
the manner in which the crime has been committed, and you are failing to bring it any mitigating circumstance. Number two. Number three, the court comes to the conclusion that by assessing whatever, that there is no chance of any reformation, because that is how it has come.
And my lord, in that paragraph, my lord, what say? In the instant case, no previous good or noble activities of the convicts are forthcoming on record or brought to the notice of this court, my lord.
That is not.
My lord, it is not known, my lord, what the
No,
court
that
expected.
is. Please listen to
Yes.
it.
It is not material, sir.
Yes.
Someone committed a good thing, not committed at all. It's not a criteria.
Not a criteria. Your lordship. What I say, my lord, your lordship, para 64, what they say, my lord, simply placed some judgment, citation of judgment, lordship. Before concluding, it is worth to mention here that in five decisions have been given, my lord, which is a case based on circumstantial evidence. The Honorable Supreme Court has confirmed the death sentence, my lord. Thus, in view of the aforesaid discussion, allowed the director for death sentence. Your lordship, those decisions, my lord, Lakshman versus State of Orissa and others, my lord, AR 1995, my lord, that relates to 375 case, 376 case, related to 370.
No, just forget about the decision. Just come to the when the language of that decision which you placed before us.
My lord.
That merely because it comes within rarest of rare case, it's a grave crime.
Yes.
Merely because it's a grave crime, that would not be a ground to impose death sentence. Merely because the accused has failed to prove the mitigating circumstance, that also not a ground to death sentence. In addition to that, what that decision says, that it is to be seen that whether there is no chance of reformation. So how, whether there is any decision to judging that there is no chance of reformation, what is to be looked into by the court? Whether
there is no such guideline. What the previously said, my lord, there is no guideline in a particular way this should be judged.
Every crime is committed. Just crime is committed, which cannot be committed by a prudent man.
Yes.
And it has shocked the conscience of the society. Then it becomes a rarest of the rare kind. Otherwise, not. So it has to fit into that rule.
Yes, ma'am.
So now the question is whether in the present set of facts, a rarest of the rare kind is made out or not.
My lord.
Number one. Number two, whether after having committed such a crime, there is no possibility at all of reformation.
Yes. Let us accept for a moment this is a rarest of rare case. Let us accept that is the rarest of rare case. questions whether death penalty, death
No,
sentence.
no. Once you come to the conclusion that it is a rarest of
That
rare
is to be
case,
excluded, sir.
that is to be excluded.
It has to be excluded altogether.
Rarest of rare case is to be excluded. Only material is to be brought on record that it is a ghastly crime. And even in such a case, even the accused has failed to prove the mitigating circumstance. Still, then there is also the necessity on the part of the court to see whether there is no chance of reformation. How the court is to assess that part, that this accused is such that whatever he has conducted or he has done, there is no chance of reformation. So that that particular thing is to be assessed. If you read the sentencing,
Suppose there is
I understand.
there is a cold-blooded murder. There is a killing spree, and the person who has committed is a hardcore criminal. Then the court may realize that no such person cannot be let off. It's a rarest of the rare case, and there is absolutely no possibility of any reformation.
Yes,
ଏଇ ଜିନିଷ ଗୁଡ଼ା ଆଣନ୍ତୁ sir.
this should be.
you can get it if you go through the books on sentencing. ତା ଦେହରେ
Policy,
sentencing ର
policy.
policy ଯୋଉ ଅଛି, reformation ଗୋଟେ chapter ଥିବ.
Yes.
ସେ reformation ଟାକୁ କେମିତି court judge କରିବ, that there is there, that is there, that is one of the thing which is the while imposing the sentence the court has to look into, not the ଯୋଉଥିରେ minimum sentence prescribe ହେଇଛି,
ଛାଡ଼,
that is to be given, that is a different part. But where the court has been given discretion which may extend to this year, so in such a case opportunity is obviously given to the accused also to have his say, and various things are to be taken into account. So what would be the appropriate punishment in a case? So there also sometimes this thing has been discussed, and this part, particularly when the reformation angle, as you pointed out from that decision, it is one of the thing which is to be looked into by the court. And that means what the court says indirectly, that merely because the crime is very serious in nature, that does not automatically mean that there is no chance of reformation. Indirectly, they have hinting it out like that.
Manner of act is such that there can be no reformation.
That is
what she say.
Or on the basis of past conduct, that there is no chance of reformation. Past conduct, one thing, or the crime itself, it is of such a that it is so.
କିନ୍ତୁ କହୁଛନ୍ତି ଗୁଡ୍ କଣ୍ଡକ୍ଟ ଦେଖେଇ ପାରିଲେନି, ତାଙ୍କର ଯୋଉ ଜଜମେଣ୍ଟ କଲେ ପ୍ରିଭିୟସ୍ ଗୁଡ୍ କଣ୍ଡକ୍ଟ କି ଦେଖିପାରିଲେ, ଗୁଡ୍ କଣ୍ଡକ୍ଟ ହ୍ୱାଟ ଦ କୋର୍ଟ ଏକ୍ସପେକ୍ଟେଡ୍ ଦ୍ୟାଟ୍ ଇଜ ନଟ୍, ମାନେ ଗୋଟେ ପୂର୍ବରୁ ବ୍ୟାଡ୍ କଣ୍ଡକ୍ଟ ଦେଖେଇଲେ ଗୋଟେ ଅଲଗା ଜିନିଷ, କିନ୍ତୁ ଗୁଡ୍ କଣ୍ଡକ୍ଟ ହ୍ୱାଟ ଦ ୱାନ୍ ଆକ୍ୟୁଜ୍ଡ କ୍ୟାନ୍ ଶୋ ଦ ଗୁଡ୍ କଣ୍ଡକ୍ଟ ଇନ୍ ଦ ମିନ୍ ଟାଇମ୍. ହଁ କାହାକୁ ଗଣ୍ଡଗୋଳ କରିଦେଇଛି, ମାରିଛି, ମର୍ଡର କେସରେ ପଶିଛି, 3-4ଟା ଆଣ୍ଟିସିଡେଣ୍ଟ ଅଛି ଅଦରୱାଇଜ, କିନ୍ତୁ ମୁଁ କହିବି ଗୋଟେ ଲୋକଟେ ଗୁଡ୍ କଣ୍ଡକ୍ଟ, ମୋର ନିଜର ଗୁଡ୍ କଣ୍ଡକ୍ଟ ଅଛି, ଆଇ ଡୋଣ୍ଟ ନୋ what that can be assessed. No previous good and noble activity.
Says that 53 says in Evidence Act that in criminal cases previous good character is relevant. What the court has observed, that you have failed to show that what is your good conduct or what is it. That is what they say. Yes.
ସେ ଯୋଉ ଡିସିସନ କାହିଁକି 64ଟା କହୁଥିଲେ କି ଯୋଉ ଡିସିସନଟା ଅଛି ରାଜେନ୍ଦ୍ର ପ୍ରହ୍ଲାଦର ୱାସନିକ ବର୍ଷା ସେ ଅମୁକ, ସେଥିରେ ଗୋଟେ ସେଣ୍ଟେନ୍ସ ବୋଲି ଅଛି ବୋଲି କହିଲେ, ସେଥିରେ ବି ସେୟା କରିଛନ୍ତି, ତାକୁ ଇଏ କରିଛନ୍ତି, ଲାଇଫ ଇମ୍ପ୍ରିଜନମେଣ୍ଟ କରିଛନ୍ତି ସେ କେସରେ. ସେ କେସରେ କନସିଡର ଦ ସର୍କମଷ୍ଟାନ୍ସିଆଲ ଏଭିଡେନ୍ସ.
Any decision on witchcraft and murder?
We pointed out, right?
Witchcraft murder ଆଉ ଗୋଟେ ଖାଲି କହୁଛି, my friend will show, but ତା ପୂର୍ବରୁ ମୁଁ ଗୋଟେ କହୁଛି, ଗୋଟେ ଡିସିସନ ସେ ଜାତୀୟ ଆମ ଏଗେନ୍ଷ୍ଟ
ଗୋଟେ I think there is one case, ତାକୁ ଗୋଟେ ସ୍ୱପ୍ନ ଆସିଲା ଯେ ଯଦି ତମେ ଗୋଟେ ଛୁଆକୁ ସାକ୍ରିଫାଇସ୍ କରିବ ତାହେଲେ ତମେ ଏଇ ଜାଗାରୁ ତମେ ଗୋଟେ ପୋତା ଧନ ମିଳିବ ବୋଲି ମାନେ ଇଏ କରିବ, ମିଳିବ ତମକୁ ଏଇ ଟାଇପ ର. ସୋ ଦ୍ୟାଟ ୱାଜ ସେଇ ଇଏରେ କ୍ରାଇମ ଟା କମିଟ ହେଇଛି. So child sacrifice is for that. So the uh, purpose is one of that.
Purpose,
Here we are, what has been told that witchcraft activities ko nekini, there are case
Yes.
of the prosecution that 3 persons have been,
killed.
so whether in such a case, what any
सर जो
citation?
हम ଗୋଟେ citation ଗୋଟେ ଅଛି ଏଟା against us
Hmm.
जो child sacrifice କରିକି just to get the treasure ଏଟା
No, it is
self
not a
interest
child
ମାନେ
sacrifice.
ମାନେ ଗୋଟେ case
Ah,
ଟା ଗୋଟେ
that
case ଟା
we pointed out. Child
ହଁ
sacrifice
child
for
ସେଇ case
treasure.
particular ସେଇ
That,
case ଆପଣ ଯୋଉଟା କହୁଛନ୍ତି
that is a
child sacrifice ହେଲା go to get the treasure
Hmm.
ହେଲା ସେଥିରେ କୋର୍ଟ କହିଲେ no he cannot be excused
Hmm.
death penalty
Hmm.
death penalty awarded
Hmm.
କିନ୍ତୁ ଆଉ ଗୋଟେ case ଟା କହୁଛି ସେଥିରେ କୋର୍ଟ 3 ବର୍ଷ ଦେଇଥିଲେ 3 years ମୋର ଆୱାର୍ଡ ଦେଇଥିଲେ ପଢିବି ଦେବି ଆପଣଙ୍କୁ
Hmm.
ଦେବି ସେଥିରେ କିନ୍ତୁ ହାଇକୋର୍ଟ କଲେ 7 ବର୍ଷ କଲେ
Hmm.
that is confirmed by the
Hmm.
Supreme Court
Hmm.
ନାଇଁ ଯେହେତୁ ଗୁଣି ଗାରେଡି କରିକି ଏଗୁଡାକ କରୁଛ sorcery activities there
Hmm.
no they cannot be escaped
Hmm.
light punishment has been enhanced
Hmm. ଶୁଣ,
death sentence का ଅଲଗା ଜିନିଷ ଏଥିରେ ହଉଛି
ଗୁଣି ଗାରେଡି ପାଇଁ ଯଦି ମର୍ଡର କରାଯାଏ, ମାସ୍ ମର୍ଡର, it's a
ହଁ
3
ହଁ
murders, it would be itself a come within rarest of rare case. ଏଇ type ର decisions ଆମେ କହିଥିଲୁ search it out,
Sir.
or it would be in such a case also liberal attitude is to be adopted, and the death sentence would be to that altered to that life imprisonment. So that is to be also taken into account.
That may not be necessary
All right.
ଏଇ ଯୋଉଟା
please.
କହିଲେ may not be this
All
may
right.
not be necessary my
Not
friend will say
necessary. Yes. Leave it. Anything else?
ଯୋଉଟା my friend ଗୋଟେ ଅବଜେକ୍ଟ କରିଥିଲେ ଯେ ତାଙ୍କର 164 ଷ୍ଟେଟମେଣ୍ଟ ଆଉ 160 ଯେ ଲୁଚିକି ଯାଇ ପଳେଇଲେ ତାମାନେ ଏପର୍ଯ୍ୟନ୍ତ ମେଣ୍ଟାଲି ଇଏ ହେଇଥିଲେ ଯେ ଲୁଚିକି ଯାଇ ପଳେଇଲେ ଯାଇକି ଏଫଆଇଆର ଦେବାକୁ ଗଲେ ଦ୍ୟାଟ୍ ଇଜ ନଟ୍ କରେକ୍ଟ କାରଣ ତାର ନିଜର ଏଭିଡେନ୍ସ ହଉଛି ମୁଁ ଗଲି ଆଉ ଗୋଟେ ଲୋକ ସହିତ ଗଲି ଆଉ ଗୋଟେ ଲୋକ ସହିତ ପଏଣ୍ଟ ଆଉଟ୍ କରୁଛି ଏଟା ଯୋଉ ତାର ଏଭିଡେନ୍ସ ହଉଛି ଯୋଉ ସେକେଣ୍ଡ ଥର ଯୋଉ ରିମାଣ୍ଡ ହେଲା ପରେ ଯୋଉଟା ହେଲା ସେଟା ଜଷ୍ଟ ସେଟା ଖାଲି ଗୋଟିଏ ଖାଲି ଲାଇନ ଖାଲି କହିଦଉଛି 149 149 ହେଇଦବ ହଁ 149 ସେଥିରେ କ୍ରସ୍ ଏକ୍ସାମିନେସନରେ is accompanied by ward member Lugosavar while proceeding to the police station to lodge the report. 149 paragraph 2. କିନ୍ତୁ ଏଇ ଯୋଉ 164 ଟା କହିଲେ 64 ଟା you lordship see 64 ରେ ପେଜ ଦେଖିବେ 99 ପେଜ 99 10 paragraph 10 ମାତ୍ର 15 ତାରିଖ ଦିନ ସେମାନେ ସବୁକୁ କାଢି ପେଟ୍ରୋଲ ଢାଡ଼ି ପୋଡ଼ିବାରେ ମୋତେ ଆସି କହିଲେ ଏହା ଜାଣି ମୁଁ ଲୁଚି କରି ଯାଇ ଶୁକ୍ରବାର ଦିନ ପୋଲିସ ବାବୁଙ୍କୁ ସବୁ କଥା କହିଲି ତ ତାଙ୍କର ଭ୍ୟାରି କରୁଛି ହାଉ ଡୁ ଭ୍ୟାରି ପଛରେ ଯୋଉଟା କହିଲେ ମୁଁ ଅନ୍ୟ ସହ ଯାଇଥିଲି ଆମର କେସ୍ ହଉଛି ଆୱାର ପ୍ଲିଜ ଦେ ଆର୍ ମେଣ୍ଟାଲ ଫ୍ରି ଥ୍ରୁ ଆଉଟ୍ ଫ୍ରମ୍ ଦ ଡେ ଅଫ୍ assault they don't know when they died or not nobody knows but from the day of assault he was free to he has free mind no he was not restricted in any manner because
our movement has not been restricted.
କହିଛନ୍ତି ତାପରେ thereafter this remained in the house of some other my lord on the first day remained in the house of ବୁବୁନ my lord
Right.
ବୁବୁନ ଯିଏ ହଉଛି କିଏ ନା ସିଏ ହଉଛି ତାକୁ ଜ୍ୱର ହେଇଥିଲା ଏବଂ ସେ ତାକୁ ତାର ଆଲିଗେସନ ହଉଛି ଛୁରୀ ଦେଖେଇଥିଲା
One of the accused appellant is.
ଅଜନ୍ତ ବି ତାକୁ କହୁଛି ମରାମରି କରିଛନ୍ତି ଅଜନ୍ତ ବି ସେଦିନ ତାକୁ ଦେହ ଖରାପ ହେଇଥିଲା ଆଉ ଘୁଙ୍ଗୁରି ଯିଏ କହୁଛନ୍ତି ଡେଙ୍ଗୁନ ସାପର ଯିଏ ୱାନ୍ ତାର ଭଉଣୀ ତ 3 ଜଣ ଯାକ ଦେହ ଖରାପ ହେଇଥିଲା 3 ଜଣକୁ 2 ଜଣ ଯାକ ହଉଛନ୍ତି ଆକ୍ୟୁଜ ଅଜନ୍ତ ଆଉ ବୁବୁନ ଯୋଉ ବୁବୁନ ତାକୁ ଛୁରୀ ଦେଖେଇଥିଲା ବୋଲି କହିଲା ଆମକୁ କଲା ତାରି ଘର ଯାଇ କହିଲା ମୁଁ ତାରି ଘର ତାକୁ କହିଲେ ଯୋଉଠି ରହୁଛୁ ରହ ତୋ ଇଚ୍ଛା ହଉଛି ଯାହା ଘରର ରାତି ହେଇଛି ସେ ରହିଲା ଷ୍ଟେଡ୍ ଇନ୍ ଦ ହାଉସ ଅଫ ବୁବୁନ ଦେୟାର ଆଫ୍ଟର ହି ୱେଣ୍ଟ ଟୁ ଦ ହାଉସ ଅଫ ଅଦର 4-5 ଦିନ ରହିଲା ସେ ଅଲଗା ଲୋକଙ୍କ ଘର ରହିଲା ସମିତି ମେମ୍ବର ଇତ୍ୟାଦି so there was no restriction for movement of hormone
All right,
that part now he what my learned friend point out secretly what means what my learned friend wanted to say that he was so apprehended of a danger to the danger of her life or the threatening that he wanted to secretly go and to lodge the FIR. That is not correct because her own affirmation, own evidence that I went to go
without the notice of the
accused persons.
secretly mana kon without avoiding the notice of the accused persons, she managed to go to the PS. এটা ବୁଝିବାକୁ ପଡିବ। ଲୁଚି
Maybe.
ଛପି ମାନେ କଣ କୋଉଠି କାହା ଘରେ ଯାଇ ଲୁଚିଥିଲେ ନା କାହା ବାଡି ପଟେ ଲୁଚିଥିଲେ ନା କଣ?
ନାଇଁ ଯାଇଥିଲେ ଫ୍ରିଲି ରହିଥିଲେ ଅନ୍ୟ ଘରେ ରହିଥିଲେ।
Persons, she managed to reach the PS on the way accompanied by Lugu or
Lugu.
Right.
The person who has scribed the
P5
FIR.
को बोला
हाँ.
Went with P5 7 P7 149 149 ଟା କହିଲେ ପୁରାଟା I was accompanied by ward member Lugu Sabar while proceeding to the police station to lodge the FIR. We have proceeded in motorbike by proper road. The content of my report as narrated was disclosed before anybody, was not disclosed before anybody till its submission. It is a fact that I have not stated during examination under section 100 that is different. This thing I wanted to point out. And as far, my lord, another point, just one point bring to lordship's notice, my lord. As far as the cremation is concerned, my lord, burial and cremation. Prosecution has not pointed out as to where they buried or and no material evidence is there because my lord, your lordship consider this thing, but 3 persons have been buried and thereafter after several days, 5 or 6 days, my lord, they were exhumed and they're burnt. Nothing is explained as to if they burnt and what material was used to burn by. Even though someone has said kerosene or petrol, the lordship has consider where they have brought it or not, nothing, no material is there. And nobody has seen who killed her or what role was played by any of the accused. Nothing was proved. Was not accused. Whenever the death is, whenever, my lord, this is a question of that they have, as per the statement of direct witness, they were taken from while he was living, but they have life. But subsequently, it said that they had been killed, but no matter is there. Unless they have been said to have been killed, the proved.
It's all
Question
like
of
that.
160 will not come into operation.
The
But no lordship.
he has state council has fairly stated that the
confronted to anyone.
Huh?
Whether it has been confronted to anyone. Any suggestion to any of the witnesses in absence of direct evidence that the bodies were burned by petrol, kerosene, any evidence from the side of
Their evidence.
any suggestion?
My lord, suggestion we cannot give because we don't know how did I. We cannot suggest. We suggest means we are aware of this.
There is no evidence at all, sir. Where is the question?
Prosecution has not adduced any evidence to adduce any evidence what overtact has been played in the even if the so-called let us say date or so-called burying the dead body or then exhuming and again whether all of them participated or some of them participated, what role had that is not totally there.
But in FIR, what the informant says, lordship last line. ନିଜ ଆଖିରେ ଦେଖିଛି ଟିକେ ଗୋଟେ ଲାଇନ ଖାଲି ତାପରେ ସେଇ ଗୁହାଳରୁ ଜଣ ଜଣ କରି ମୋ ନାନୀ ମୋ ବାପାଙ୍କୁ ଦରମରା କରି ନେଇ ନାଇଁ ମଶାଣିରେ ପୁଣି ପିଟି ପୁରା ମାରି ଦେଇ ପୋତି ଦେଲେ। This is the FIR, my lord. Though that has not been substantiated in the evidence. So from very prima facie, it will show that as if PW has seen this, that at the cremation ground they have assaulted and buried them. So what I wanted to say, my lord,
it may be said that she learnt about it, sir.
On the my lord,
that
is nothing there. Nothing there, my lord. What my lord?
So she was present physically at the first place, but subsequently learnt about the.
From where learned that is not.
Victims have been taken to the burial ground.
ଅଲଗା ହେଇଥାନ୍ତା ମୁଁ ଶୁଣିଲି ମାରିଦେଲେ ଅଲଗା ଜିନିଷ ତାକୁ ପିଟି ମାରିଦେଲେ ପୋତି ଦେଲେ କିଏ କହୁଛି କଣ କହୁଛି no matter.
It was
that I wanted to point out because
that has already been discussed that there is no material who informed when how it came to knowledge खाली
Nothing.
ଗୋଟେ line କହିଛି ଯେ ଆମେ ମାରିଦେଲେ ବୋଲି.
କିଏ କହିଛି କଣ କହିଛି nothing.
It's all right.
All right.
That is already we have noted down.
That is okay, my lord. That is okay on my part.
Anything you want to add, just add. Don't repeat.
No,
what
I
you
am not
have
repeating,
already
my lord.
said.
What my learned friend pointed out that just
No, you
giving
took, you
I am
said
not
that I have something to add.
going
We
there.
thought that let him you add first and then we'll finally. So yes, Mr. Then
This is
it's over.
this
Okay.
is my part.
So what, Mr. Das, you want to say finally, or anything you want
Mr.
to?
Chand is to
Chand,
add
yes.
witchcraft and murder decision.
But I have got some
Referring
judgment. I need some time because I'm up to only after lunch. As you know, my lord is not sitting after
We are
lunch.
not having bench
But
after
I have one judgment. It covers everything. Although it's of not the apex court and it's not binding up, but is a persuasive value. State of West Bengal versus Kali Singh, where also around 7% has been murdered. This by this witchcraft.
Witchcraft.
Everyone has been acquitted, and there everything has been discussed, and the honorable court has also gone to section by directing the state for compensation scheme, my lord.
Mr. Das,
because he is to also.
you are to. We think that in view of the paucity of time today, we cannot finish this matter today. You have not completed your argument, so he has to address something. So let us keep it on Monday. Then, so it will continue. And in the meantime,
I'll file the
that
judgment
written note of submission.
submission,
Brief,
also
it
citation.
should be brief to the point,
Yes, sir,
and
yes.
citation also only. Don't paragraph numbers and on which point if you want to cite death reference this decision this particular line
Madam.
single witness this line all these things like this don't give it so
We can close the hearing by
who is to the count
Next one, second, Vibhuti Party.
and who is to argue from the side of the condemned prisoner
Jafrullah.
Jafrullah. Okay.
I got the two judgment wherein the apex court has said like this, my lord. As the case involves commission of offense by a large number of persons, it is necessary to evaluate the provisions, the prosecution evidence of each of the appellants as to the presence of presence and participation in the crime, a rule of
prudence, though not a rule of law, was laid down by apex court in Masalti versus State of Uttar Pradesh, 1965, AIR 202, in regard which is as follows.
maybe a case of mob violence.
the mob violence.
Mob violence. That's it.
There also this act of social is
Large
there.
number of
That is also
persons
there. It is
But where a criminal court has to deal with evidence pertaining to commission of an offense involving a large number of offenders and a large number of victims, it is usual to adopt the test that conviction could be sustained only if it is supported by 2 or 3 or more witnesses who give a consistent account of incident. In a sense, the test may be described as mechanical, but it is difficult to see how it can be treated as irrational or unreasonable.
large number of persons committed the crime, large number of victims.
ନାଇଁ ସେଇଟା ସେଇ ଯୋଉ କେସଟା କହୁଛନ୍ତି ଆପଣ ଗୋଟେ ଷ୍ଟ୍ରିଟ୍ ରେ ହେଲା ଯଦି ହେଲା ତାହେଲେ ଦ୍ୟାଟ୍ସ ଏ ଡିଫରେଣ୍ଟ ମ୍ୟାଟର ଏଠି ଯୋଉ ଜାଗାରେ ଘଟଣା ହେଇଛି
ସେଇଠି କହିଲେ ଯେ it would be a
ଏଠି
risky proposition to accept the evidence unless until there is a
ଏଠି କୋଉଠୁ ଆଣିବେ ସିଏ ଆଉ ସାକ୍ଷୀ କୋଉଠୁ କଣ ଧରିକି ଆଣିବେ ନା କଣ
similar to this, and there also the things were there. A solitary witness evidence was taken care of, and the apex court has
under what circumstance the crime was committed, sir? So many persons involved, so many victims.
no in the particular case, my lord, many
What are the facts of the case?
depends on the fact.
କୋଉ ଜାଗାରେ କମିଟ ହଉଛି କୋଉ ସମୟରେ କ୍ରାଇମ ଗୋଟେ ଘର ଭିତରେ ଆପଣଙ୍କର କ୍ରାଇମ ହବ ଆପଣ କହିବେ କେହି ଇଣ୍ଡିପେଣ୍ଡେଣ୍ଟ ୱିଟନେସ ଇଏ କରୁନାହାନ୍ତି ବାହାର ଲୋକ କେହି କହୁନାହାନ୍ତି ତା ଘର ଭିତରଟାରେ କ୍ରାଇମ ହବ ବାହାର ଲୋକ କୋଉଠୁ ଆସିବେ
ଅଲଗା ଲୋକ ଗୁଡା ଭିତରେ
ମୁଁ କହୁଥିଲି it depends upon the fact
facts and circumstances. I do consider. The other
And,
witnesses have not supported.
it is she
I'll
କେମିତି place କରୁଥିଲେ Mr. Das was placing ସବୁ ଜାଗାରେ ଆପଣ ଯେ number of
State record-
witnesses ପାଇବେ ଏମିତି କିଛି ମାନେ ନାହିଁ
ନାହିଁ।
ଗୋଟେ ଗୋଟେ ଜାଗାରେ କ୍ରାଇମ ହଉଥିବ ଯୋଉଠି only solitary witness ଥିବେ ତେଣୁ no straight jacket formula
Formula
that wherever there is only one witness is that his evidence is to ସେଥିପାଇଁ ତ କୁହାଗଲା ଯେ solitary witness ର testimony ରେ ମଧ୍ୟ conviction ହେଇପାରିବ
ହେଇପାରିବ,
provided
subject-
that clear, cogent, trustworthy, and reliable.
And also some corroboration. There are no
Right.
corroboration. So I will satisfy madam. And I will give all required.
So that's all.
I may be.
Yes.
One matter, your lordship granted interim bail, which is expiring day after tomorrow. My memo was allowed, but that bench, now the assignment, the matter will not come, that's why delisted.
Surrender. Move.
Her mother's condition is she precariously and she
It
is
is
at
only
hospital.
for, some death has taken place. That is how it has come. Yes,
If it will be taken up on Monday, then
file your memo. See that.
May I please, my lord? It's an interim application to release the convict bail. In the meantime, my lord, he has taken the ground that his brother was under treatment and he was the only able member. Now he has passed away. He just died on 20th April. This 20th April.
No. This IA has come for interim bail.
Interim bail, my lord.
When you filed the interim application, the brother was alive.
Yes.
Then, when death took place.
Kodiyachari.
So, where is the document? No, have you? Really?
He died. Original.
No, it should not be filed in this way. It should be filed with a memo. Say, this memo, no. You have to file paper, a memo like Now, have you a copy has been served on you? And you have instruction.
No, that just now he has served.
When that death took place?
Kodiyachari.
Kodiyachari mane 1, 2, 4, 5, 6. Today is the 7th day.
Yes, this is certificate from the hospital.
That hospital.
No, it's all Mr. Tripathi.
Yes.
Let the judge, concerned trial court verify,
Yes,
and
yes.
if through the IAC, if it is found to be correct, then we will fix the time that for this period he will go on verification, right? That, but file with a memo that I'm filing a death certificate.
My lord, I'm filing.
Original ta di tapare, chala. IA number 765 of 2024. This is an application for interim bail. Mr. Das, Land Council, submitted that though at the time of filing of the interim application, ground was taken that the elder brother of the petitioner was suffering from cancer and was under treatment, but on 20th of April 2024, the elder brother of the petitioner has expired. And in support of such contention, he has filed a memo annexing the death certificate issued by Utkal Hospital. The Kodigara Hospital,
Bhubaneswar.
Bhubaneswar. The memo is taken on record. The Learned Council for the state submitted that though he has received the copy of the interim application, so also the death certificate, but in view of the paucity of time, it is not possible on his part to obtain instruction on the death certificate. Considering the submission made by the Learned Council for the respective parties, the document filed by the Learned Council for the petitioner and for the submission that the presence of the petitioner is necessary for performing the obsequies ceremony, I am inclined to release the petitioner on interim bail for a period of 10 days from the date of release, subject to verification of the contention raised by the Learned Council for the petitioner that death of the elder brother uh, of the petitioner has taken place on 20th of April 2024. In that respect, the London Trial Court shall obtain instruction through the inspector in charge of Shendipada police station. And if it is found to be correct, then only the bail bond shall be accepted, right? Immediately certified copy the order upload kar diyan karo.
May I pray your lordship may say 15 days.
All right,
15 दिन.
make it 15 days. All right.
Urgent certified copy.
Yes, yes.
In course of the day. Yes, my lord.
এটা পরিবার মুখলে please.
One month extension.
It is the letter dated 9/4/2024 of the Land and Prestigious Kurda at Berhampur,
Boris.
sorry, Bhubaneswar, who has sought for extension of 1 month time for disposal of GUA dot P under number 22 of 2023. Stop. Time is allowed. Intimate to the concerned court.